I'm Eric. Looney asked me to come today to talk a little bit about benefit corporations, Washington's version of that, which is called the Social Purpose Corporation, and then the newest iteration out of Delaware called the the Public Benefit Corporation. We'll start kind of the hybrid entities in general. It's a new kind of an exciting area of law and that a lot of social entrepreneurs have been drawn towards. It got started some time ago. A nonprofit by the name of B Labs, founded by Jay Cohen, started out with what was originally called a B Corp, which is a certification. And what he did was he sort of looked at the restrictions around fiduciary obligations that officers and directors owe in classic for-profit settings. And they kind of decided, well, there should be some flexibility for companies that want to have a social purpose or a social good of some kind, create an impact, and have a benefit on the community. And classic fiduciary obligations of officers and directors of for-profits were very restrictive. The classic example is Ben & Jerry's. They were forced essentially to sell out to Unilever when they didn't want to. Although that has gone better than was predicted, that was kind of the impetus of all where it started. And it started with B Labs, and it started with a B Corp certification, which is not an actual entity type, which is more like a Better Business Bureau certification of sorts. You get a stamp of approval where if you go through their process, you take their assessment, you amend your articles of incorporation, your governance documents to be consistent with the language that they want to see, and you pay an annual fee to them and agree to abide by their standards, then they'll certify you as a B Corp and say, we recognize that you are taking the steps necessary to meet our standards. You have to have a third-party assessment every year. You have to publish the results. Very interesting stuff, very cool stuff. B Corp is where it all started. The next iteration of that became Benefit Corporation. Maryland was the first state in 2010 to adopt benefit corporation legislation. Benefit corporation was the actual creation of an entity that kind of embodies the DNA of what the B Corp was or is. And benefit corporations are corporations. They're for-profit. They don't receive any tax advantages in terms of being a nonprofit because they're treated as for-profits. But there's additional flexibility baked into the legislation for officers and directors as it relates to their fiduciary obligations it's defined as stakeholders, which essentially means your shareholders, your employees, the community around you that are directly involved and have an interest in your business. The community at large would not be defined as a stakeholder, but the idea with benefit corporations is board of directors are required to take into account a general or specifically identified public benefit that company has identified as important, and they're accountable for it on a yearly basis. That's a big point of emphasis in benefit corporations is accountability and transparency. So every year you have to create a report, you have to publish those reports, you have to use an identified third-party standard to create your report. And benefit corporation legislation has been very popular, and I think is currently passed in 20 states nationwide. It is pending in 18 more, so pending in various stages of either being proposed or having been signed and awaiting enactment, I believe. So looking at about 38 states right now that are headed in that direction as far as benefit corporations go. What's important about, pardon?
Sorry, Texas is on the list?
I believe Texas is on the list of pending, but I can check that. But what's important about benefit corporations in terms of identifying the impact that they're creating is that it not only expands the fiduciary duty to allow officers and directors to use corporate resources to further their public benefit, but it also creates accountability standards for them. And that's something that is kind of, it's not well fleshed out, I would say, in the legislation, but it's clear that that's the intent. Stakeholders of a public benefit corporation are provided with a specific derivative action called a benefit enforcement proceeding, which enables them to actually hold the officers and directors to the standards and say, you didn't do what you were supposed to do, and they can bring action to try to enforce the purpose of what the benefit corporation is created for. In Washington State, we have a slightly different version of a hybrid entity. It's called a social purpose corporation. It is very similar to a benefit corporation. It has a few changes, and there's a couple of reasons for that. But essentially, in Washington State, there's a committee called CARC, which is the Corporations Act Revision Committee. and they took what was the proposed benefit corporation legislation, they made some changes to it, and they named it differently to distinguish it from benefit corporations, because they felt that was important to say this isn't the same, it's different. We made some changes, and that was what has been enacted in Washington State. It went into effect last year, June 7th of 2012. Social purpose corporations, as I said, are similar in concept and idea to a benefit corporation. There is some added flexibility to social purpose corporations that you don't have on a benefit corporation side. Benefit corporation legislators would argue that added flexibility means lack of accountability. So there's a little bit of a tension there. But in Washington State, we say there's added flexibility. And what it means basically is in Washington State, officers and directors of a social purpose corporation may consider their social purpose when they're taking action for their company. In benefit corporation legislation states, it's a shall consider standard. So that's the major difference that you'll find most of the tension arising out of. But in Washington State, they felt, the CAR committee felt they should reset that standard and say, if you're going to make yourself a social purpose corporation and you're going to hold out to the public that you have a specifically identified social purpose or a general social purpose, then you should have some flexibility as a board, as an officer board, to be able to define what that means to you. So there is derivative proceedings available to social purpose corporation stakeholders through the Washington Corporations Business Act. So it's similar in that regard. But by and large, it's just a little bit of a more flexible standard, a different take off the benefit corporation legislation that allows for that flexibility for the officers and directors to impact their social purpose. The actual idea of taking corporate resources that would otherwise be reserved for maximizing shareholder value and being able to divert those resources to creating public benefit or social impact are largely the same, and that's consistent. Delaware is, of course, the sort of end-all be-all when it comes to the corporation world. They have the Court of Chancery in Delaware, which has an entire court system dedicated to corporation to business law, essentially, and there's tons and tons of great precedent that has come out of the Court of Chancery, which has very clearly defined what corporations are, what the obligations of officers and directors are, what shareholders' rights are, and so for that reason, Delaware is a very, very popular state for a corporation. I believe it's something like 50% of the corporations in the United States, or over 50% of the corporations in the United States are incorporated in Delaware, and like 2/3 of the Fortune 500 companies trading today are Delaware incorporated. So Delaware came on board very recently, and they too took the benefit corporation legislation that was proposed, and they made a slight change for it and created the public benefit corporation, the PBC.
Public benefit corporation?
The PBC. So Delaware has taken a couple of different angles on this. They have replaced the shall consider language that is in the original benefit corporation legislation, but they still require their board to consider the pecuniary interests of their identified public benefit when they're taking action. So it doesn't specifically say shall consider, but it does require the board in a various, to go through a weighing process and to weigh what they're trying to get accomplished to their benefit when they're making decisions. The other things that it did was it reduced the reporting requirement from annually to biannually to every other year, and you don't have to post it to the public. Whereas benefit corporations have to go on their website, post their annual report, say here's what we did, here's what we didn't do. There are standards that are set forth for your annual report that says here's how we impacted our identified cause, here's what we can do better, here's what we're thinking about in the future, and you have to measure yourself against a third-party standard. Delaware only requires that once out of every 2 years, and further does not require that you post it to the public. You just have to make it available to your stakeholders, which it does make sense because your stakeholders under all of the legislation that's been enacted to date are the only ones that are actually provided derivative rights as it relates to your benefit that you're trying to accomplish. So it would make sense that they're the ones that are really, entitled to look at this information. The posting the rest of it to the public is more, along the lines of look at how good we're doing, and definitely provides a valuable service to be able to say, not only are we what we say we are, but here's proof that we're doing what we say we're doing. So that's a very positive thing to do that. But Delaware said we're not going to require that. We're going to pull that out.
Isn't it de facto public anyway? Do you have enough stakeholders that they share the information?
Usually not. I mean, at this stage in the game, most of the hybrid entities are not that large that you'd be talking about disseminating this to thousands of shareholders and having it show up on blogs and all that sort of thing. But it could, there's no requirement, I don't think, from the stakeholder side that they would have to maintain it in confidence. But it could eventually, get down the line. There are some very large hybrid entities at this stage in the game. The largest that I can think of off the top of my head is Patagonia. They were California's first benefit corporation, and they're a good example of a company that was pretty much a benefit corporation, or what the equivalent in Washington would be an SPC, before that legislation went into effect. They've long been renowned for their friendly, environmentally friendly policies, their concerns with their employees, and employee quality of life is a big theme you'll see running through this sort of legislation. So they were basically this before it came into effect, but when they read the statute that was going into effect in California, they said, perfect, we'll do that. And so they were the first one in California. And so that's obviously a very big company where, if you didn't have to post it publicly, it could generally become public knowledge anyways, based on the fact that a lot of people are going to know about it. So the primary interest in our practice, where we look at this stuff on the day-to-day going forward as it relates to these hybrid entities, is one, they're obviously wildly popular. Lots of social entrepreneurs and social enterprises look at this legislation, be it benefit corporation, SPC, PBC, and they say, perfect. This is what we want to see. This is how we've always felt our company should run, or this is how we're already running our small privately held company, and we would like to hold this out to the public and make it official. So it's very interesting that there's lots of momentum heading in this direction. As you can tell, 38 states pending, and that doesn't count Washington because B Labs does not count Washington in there. So it's really 39 that have had something similar to this. But so there's lots of great momentum here, but there's no case law yet. There's no good precedent to sink your teeth into and say, what does this really mean? What do these change standards that the board of directors has, that the officers have, what does it mean to consider your identified public benefit or your social purpose when you're making decisions? How does that all break down? How many resources is too many resources to divert towards an impact when you still have to run a profitable company? Those sorts of issues are sort of evolving and are very much a lot of the questions that come up in terms of what does this all mean? And that's another reason that Delaware adopting social entrepreneurship, social enterprise legislation is important, because Delaware is a very trusted state, and having them sign off and take this on really lends credence to the thought that, okay, this is going to be something that has legs. If you're a small, socially minded enterprise and you're getting started, you're still a for-profit. If you're looking to raise money, if you're looking to go out for financing, you don't want to do something that might turn off potential investors, might in some way hurt your ability to get to profitability and do all the things that a business needs to do. So being able to do something like a Delaware or having the SPCs in Washington continue to flourish and become generally accepted in the community is going to be very important to allow for the investing community to become more familiar with them, and to allow for, just in general, the court systems to understand what's going on with them, so that you don't face any kind of unknown risk by trying to do something positive socially. So, are there any specific questions, Eleni? I could ask you anything in particular you want me to cover about these?
That was good for me.
These entities.
I just got one. Just kind of curious about this. Does it make a difference which state you operate in? For Delaware, I can kind of understand it.
Yeah, so that's a great question. Does it make a difference which state you incorporate in? Absolutely, it does. For a number of reasons. One is it costs money to incorporate in one state and then operate in another. You have to keep both of those going. In most states, that's not that big of a deal. In Delaware, for instance, if you incorporate in Delaware and then register in Washington State, the cost on a yearly basis to maintain your registration in Delaware and have an agent in Delaware is minimal, $150, $200 kind of thing. In California, on the other hand, much different. The California standard is like $800 a year through their franchise tax board to maintain your license with them. And so in some instances, it's very important what state you adopt in. But by and large, we tend to, when we talk to folks about where they want to incorporate, we tend to look at like, what is it that you're looking to do in the short term in terms of getting this thing launched. In Washington State, social purpose corporations are really successful. They're flourishing. They're doing great. Lots of people are getting behind them. There's lots of positive momentum in terms of some investor groups forming funds for social investing, things like that. So that's a very positive option. If you're looking at more national, we're going to get started in a couple states. We're going to get going. We're going to be going out to major VC firms, that sort of thing. Then I think further analysis would be required. Looking at Delaware, if you really are going for the social entrepreneurship thing, Delaware would be a state that we'd probably look at pretty closely then, just to again provide that level of comfort, enable you to do what you want to do in terms of creating public benefit or social impact, but not diminishing your chances of getting launched, of getting funded, of those sorts of things, which may or may not impact, as more and more familiarity is built with these things, those sorts of issues may slide away. But for now, that's the kind of thing we look at when it's which state are you going for and how are you doing it.
Do you see Delaware becoming the conscious capital place for us? I mean, will it be parallel to C Corps? Or do you see like California becoming that state? Or
will Delaware be
the place where 2/3 of the conscious capitalistic companies incorporate?
Are incorporated? Not necessarily. Washington is obviously it has a lot to do with, at this point at least, geography. Seattle is a fantastic city for this type of thing. There's really great positive momentum here for social entrepreneurship and social enterprise. So it's very popular here in Washington. I would say it's the same in San Francisco. But there are other states, for instance, New York is one that has benefit corporation legislation on the books, but that legislation hasn't taken off in the same way. I think there was like 14 benefit corporations on the day that New York started their statute, and today there's like 18 or 19, and that's 2 years ago. So whereas in Washington you've got social purpose corporations, it's only been in effect for about a year plus, and you've got well over 60, that are in effect today. So, and more forming every week. So,
I'm thinking more long term. 10 years from now, where will 90% of the Patagonia's Whole Foods and whatnot be incorporated? Do you have any idea, or is it going to be scattershot?
I think it's going to be scattershot. I think you'll see a hub in Delaware because that's the generally accepted capital of corporation law in America as it stands right now. So to the extent that legislation was very thoroughly thought out by the Delaware legislators, and they did make some changes to the benefit corporation statute that they felt they didn't just adopt it whole cloth. They said let's look at it. They took their time to do it in a manner they felt was consistent with their corporate law. I think that will create a hub in Delaware, especially if you start to see more and more of these entities moving towards financings and working with VCs. But I certainly don't think that you're going to see Washington State or California or even a state like Texas or a city like Austin, once they get legislation, that those sorts of cities I think will always be a hub for impact and conscious and folks in general. And so you'll see lots of social entrepreneurship springing up around those and in those states.
I just wanted to contribute that I have a white paper written by a friend of mine, Dirk Samsel, who runs B-Revolution. It's like a legal Zoom for B corporations. And last year, the year before, he had done the first ever analysis of all the B Corps to date by state, their efficacy, and blah, blah, blah. So I can send that to you guys if you want.
Yeah, there's interesting, my business partner, Peter Smith, actually wrote a blog post not that long ago kind of comparing how social purpose corporations had flourished and taken off in the last year, and then looking at some other states with benefit corporation legislation in place, where that wasn't the case. New York was the primary example where that's not necessarily the case. And there's a couple reasons for that. I mean, the early iteration of benefit corporation legislation has some hiccups in it. The early stuff, some of them have required in there an independent benefit director, which is a director sitting on your board who has to be independent of the company, who is essentially in charge of measuring and creating the impact report on a yearly basis and measuring that and providing the accountability. And that's a good idea, but in reality, for a small socially conscious startup, that's very resource intensive. And you've seen some of that stuff fade out of the benefit corporation legislation as it's evolved. You don't see that anymore. And so, and now as you see Delaware setting a new mark, my guess is you're going to see a lot more benefit corporation legislation that closely mirrors what Delaware is doing. So, you know, it will evolve and it will change. So some of those early states, I think, may change their legislation for that reason. And then again, we'll see what happens through the courts. The benefit enforcement proceeding right now is untested. It doesn't really talk about how that's going to work. You would take it down to, I think, you know, in here, you would take it down to King County Superior Court and file an action, but, you know, litigation is not very efficient, and so asking a King County Superior Court judge, you know, who's got a very busy docket to say, here's, you know, we got this issue that's come up as it relates to social impact, and here's this new statute and everything. There's going to be some bumps in that road, I think, as we go along, as litigation starts to spring. So we'll see how it evolves, but you know, benefit corporations, I think the early ones, they'll start to evolve as well. They'll start to see more.
Any chance you think that they might modify the SPC legislation
The modification of the SBC statute, they might. You know, there's some concern around the concept as it relates to these entities of greenwashing sort of thing. It doesn't take anything to become one other than your filing fee. You know, if you fill out your articles of incorporation with the correct language and you pay your filing fee, you will be an SPC. And so, and the same thing with the benefit corporations. You know, so they're, you know, with the SPC in particular, if you start to see a situation where the impact is lost of the designation because so many SPCs are popping up and there's just no way to tell what kind of impact is being created by these folks, and the standard isn't holding everyone to a high enough standard, you know, then you may see that. Interestingly, in the SPC standard right now, it's a may consider, but you can alter your documents, your corporation's governance documents, to hold the board to a higher standard if you so choose. So you don't have to accept that it's just a may you know, standard.
That's the minimum.
That's the minimum. That's the floor they set, and then you can alter your documents to say we're going to take it up a level and increase our transparency and our oversight.
And if you raised it to a higher level, the board would recognize that you set a higher bar for your.
Potentially, yeah. I mean, if you raise it to a higher level, you're obviously going to be held to a higher standard. Your stakeholders would have more right, I think, to come against you, and more of an argument if you fail to do what you said you were going to do. They'd have a better argument to take before a court or a third-party arbiter of some kind and say, you know, this is the standard you set, you chose to set for yourself, and you didn't meet these measurables in any meaningful manner. So we'll see. I think, again, it's so early and it's such a positive vibe right now. You know, everyone's really excited about these sorts of things that some of this stuff hasn't quite worked its way through yet. It will eventually. You know, it always will come to the court system eventually, and so we'll see at that point. And at that stage, I think we'll have a better idea as to whether or not the legislation is materially flawed in any of the states.